Case number 113220, State of Kansas v. High Thought Tone.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of High Thought Tone. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, this is a case out of Johnson County involving a possession of marijuana with the intent to sell prosecution. The brief facts are that law enforcement was doing an investigation into potential importation of marijuana into Kansas, and through a snitch got information that maybe there was some marijuana being sent through UPS, eventually leading to law enforcement asking UPS to detain any packages that were coming to a particular address. They did that, and circumstances then led to them eventually opening that package and finding marijuana, which is the substance of the case. In this case, Mr. Tone filed a motion to suppress, claiming that the detention, particularly the warrantless detention in this case of the package, violated the Fourth Amendment. And so there were three parts to that claim on appeal. One was that in order to detain a package in this fashion, that the officers needed at least reasonable suspicion, that the officers did not have reasonable suspicion in this case, and that even if the officers did have reasonable suspicion in this case, that they detained it too long under just reasonable suspicion. So those were the three elements of the claim on appeal. The Court of Appeals assumed without deciding that you need reasonable suspicion to detain a package, held that there was reasonable suspicion based on the facts, and then held that Mr. Tone had not raised any issue about the detention, the length of the detention, and therefore precluded that claim on appeal. So my intent here today is mainly to talk about what the Court of Appeals did, and I don't have a lot, I suppose, especially on the first one. The first point being, was there reasonable suspicion in this case? The facts are briefed before the court. And
what's your argument that that doesn't arise to reasonable suspicion? I mean, there's a lot of factors here. They just didn't put a parcel watch on any package for a particular person. They had pretty much zeroed in on this particular residence and this particular person occupying the residence. Where does it fall short of reasonable suspicion?
Sure, Your Honor. I would agree that they have suspicion about this from a snitch about a person that they're investigating, Groff in this case. But the problem is there's no connection really to my client and my client's residence. The only connection is that the snitch says that the Groff is involved with an Asian person, right, and that they have a GPS locator on Groff's vehicle at some point. They don't even know if Groff is ever at this residence, but his vehicle is. But maybe you make this inference that he is. There's no evidence that my client was at that residence at those times.
But then don't they do once they find that the vehicle is at the residence, they go farther and see who actually occupies the residence, do a background check of your client, again, it's not just the car going to the residence, there's something else done. And again, reasonable suspicion is a lower standard than probable cause, so why isn't there reasonable suspicion, at least to put the parcel watch on parcels going to that residence?
Sure, Your Honor. Even when they do that investigation, and because they are kind of looking for an Asian person, and when they do look and say who's living at this residence, at least they find out that, oh, there's an Asian person living there. Let's look into his background. But there's no background with regard to my client for drug sales or drug involvement. He does have evidence. There is evidence of some violent crimes in his past and gang membership. But Your Honor, I would liken that. That's all. I mean, we have some cases that talk about like not having drug profiles. Drug profiler kind of ideas.
California connection, right?
Yeah.
I mean, wasn't the prior investigation indicating that the drugs were coming from California?
Yes.
And the resident of this house had California convictions, gang convictions in California, from which a reasonable law enforcement officer can suspect that gangs very often are involved. And so that takes it one step closer, is that this person's got a California connection. Their information is the drugs are coming from California. I mean, it kind of all stacks up, doesn't it?
No, Your Honor.
Okay.
Because, again, the idea of reasonable suspicion requires some articulable, and particularized suspicion. So under the theory, under the facts that you've laid out, it would essentially say, if you're an Asian person from California with some violent offense background, that's enough. And our position is that's not enough. That it requires inferences outside of the evidence that's particularized to this situation. There's nothing showing that this particular, this package, there's nothing particular about it. There's no information that they might have gotten from some. We can imagine situations. We have cases that we talk about where they have information that this is being sent at a particular time with a particular address, and we could look at that package and say that's particularized. Or maybe you have something about my client that's more particularized, that he's involved in some drug trade, other than he's an Asian person from California with some violent crime background.
And he lives in a house where Mr. Graff's vehicle stopped for 2 different occasions, once for 11 minutes and another one for 10 minutes. And the officer said, I associate short-term traffic with illegal drug activity. That doesn't add anything to the calculus?
I don't think so. Again, there's no witnesses that. We do know that they were there, but people stop at people's houses for 10 minutes for lots of reasons. I think stretching the idea of reasonable suspicion to say that if you stop someplace at a house
Twice in 3 days?
twice
In 3 days?
for a short period of time, that's evidence that you're a drug dealer.
Could be picking up your kid for an exchange or something. But what about the fact that the package does actually show up? Don't we have to think about that? That a package addressed from California, sent to that address, does actually materialize? Isn't that part of the calculus as well?
If there was anything particular about that package that they would have cited to, like in a lot of these other cases, that would show something that could cause you to be suspicious of that package, yes. And it might be with the package, or it might be the circumstances about how that package got there. Like I can imagine a situation where there's information that a particular package is being sent from a particular address or something like that. But that's not this
Was there information
situation.
that it was coming by UPS?
Even
There was.
the UPS person, though, said this was just a run-of-the-mill package. There's like thousands of packages that they see, just like every package that they
I
get
guess
through.
what I'm questioning as I listen to you is, does each individual piece have to be something that gives rise to suspicion by itself in order to be counted in the totality of the circumstances? Or is it really a totality, which means that these pieces inform the way we look at other pieces, rather than being in and of themselves suspicious? The package being a great example. The package shows up. Well, that's interesting because we have all this information that leads us to believe a package may be showing up. The package itself may just look like an ordinary package, but the fact that it showed up in the circumstances that we already are informed about makes it different. Do you see what I'm saying?
I see what you're saying, but Your Honor, so there were 2 parts, I think, to your question.
Okay, probably multiple parts.
So, the first answer to your question is, it's a totality of the circumstances. I know that that's the test, and particularly with regard to law enforcement officers looking at a lot of different things. And we know that there might be a lot of different situations where individual things by themselves aren't crimes, but when you put things together, we know that it can
Starts to look
raise
suspicious.
reasonable suspicion. But, so what I interpret as the second part of your question, though, you get this package. Again, it might not be in and of itself
Suspicious.
illegal, but there has to be something about the circumstances or the package, and that's not this case. They said we're stopping all packages that are coming to this address, not all packages that have some characteristic that might be consistent with drug trade, or that this package is being sent in some way, some circumstance that we can say that there's something particular about this package or packages like this that might be suspicious. It's just blanket, everything that's coming to this house gets stopped.
So there has to be something suspicious about the package, regardless of the reasonable suspicion that leads to its hold or its it's called a parcel watch.
Something suspicious about the package or the circumstances.
And I guess why I'm not seeing why these circumstances don't arise to mitigate the suspicious nature of the package, because you can hide anything in a package. I mean, that should just disqualify it per se, should it?
Sure, but Your Honor, I mean, flip that though, and that would be the problem. If you take that to its extreme, that means really you have no privacy in packages. Because you're right. I mean, you can any package I get, every Amazon .com thing I get could be drugs.
But there's a totality of circumstances that's informing the officer that in these circumstances, yes, it might be any package you get given these circumstances.
And our argument is that there's not that connection in this case.
Right, I understand.
That this was a package. There's nothing about the circumstances of where that package was particularly sent from, and there's no particularized showing that my client or any person in that house, it's our view, our argument, that just showing up at a house twice doesn't show that there's any particularized information about that house being involved in drug sales, and therefore it lacks that nexus.
If there had been a hold specific to packages from California, would that have been specific enough, given the tip that was given?
California's a big state. I mean, I don't want to concede. I mean, it's certainly a step better.
And just to clarify factually, isn't my understanding is that is what happened here? Am I incorrect? Because, and I thought I heard you argue that the hold was on all packages, but I thought the hold was specific to California. Am I wrong about that?
I'll review the court's order when I sit down, but I thought it was all packages, but I don't want to overstate that if I'm wrong on that.
My memo shows Stein also told Carr he was specifically looking for packages coming from California. Not that it necessarily was holding just packages. It's unclear. Maybe you have better information when you get done.
I don't know if I do, but I'll look when I sit
Let me
down.
just kind of move on here. Let's just for argument's sake say there's reasonable suspicion is satisfied for the parcel watch, and then Stein gets the dog, the narcotics dog to come out and sniff. Doesn't that turn that into probable cause at that point?
At the time they have the dog sniff, that would turn it into probable cause. Our argument is it's already too late.
I know that's your argument, but once it does turn into probable cause, then is it over at that point? If we find that it does.
If you find that there was reasonable suspicion and that there was no illegal detention.
Right, I understand.
Too long of a detention.
Too long of a detention, but this dog sniff took place way prior to when even any expectation of delivery occurred.
Yes. Okay, so I've got 14 seconds left.
We'll give you more time.
Okay, so it goes to the third issue then, because the Court of Appeals, first of all, said we were precluded from even talking about the length of the detention in this case. And so I first of all just wanted to respond to that to say it's our position that we raised a motion to suppress based on the Fourth Amendment regarding the detention of this package, and that it's our position that preserved issues regarding the Fourth Amendment. When we argue in a motion that there was a warrantless, in this case seizure, that puts the burden of proof on the state. And when there's a warrantless seizure, the presumption is the seizure is improper under the Fourth Amendment.
Our procedural statute, though, requires that motion state the facts on which you base the claim. And when looking at the motion that was filed here, it says nothing about the length of the detention. It's fairly specific about the other issue. And isn't the purpose of that statute to narrow the focus so that everybody knows? I think the words that we've used before is that otherwise it'd be like a fire hydrant, that the state would have to start and run through every possible exception to the Fourth Amendment if we didn't require the defense to be specific as to what their claim was at that point. And that motion does not raise a question of length of or reasonableness of the length of the detention. So what do we do with that?
So the statute does require us to put on the facts to show the illegal search. And the facts from the defendant's standpoint is it's a warrantless search. Therefore, it's presumed illegal. Now, state, you have the burden to prove it's legal. And you have to put on that evidence. I would liken it to a defendant going to a trial. Defendant pleads not guilty. That puts the burden on the state to prove all the elements of the crime. And we can think of situations, we have these situations, where a defendant at trial might say, well, we think the state didn't prove this thing. And they obviously lose if we have the case on appeal. And we get the case on appeal, and as an appellate lawyer, I go, oh, well, I don't know about that, but they clearly didn't prove this thing. And they had the burden to prove the elements of that crime. My client is presumed innocent. They didn't prove that element. And we talk about that on appeal. I would liken it to that. That in this case, so do they have to go through every exception? I think they have to prove the legality of the search. So they have to prove whatever exception they think applies and that it completely applies. And when we get a situation like this where we can make an argument on appeal that our argument that it was detained too long, that is included within what was raised below, because we said it violated the Fourth Amendment because it was a warrantless seizure. And so the last point, just to get back to Justice Rosen's final point, is just the detention in this case isn't just, it's not the fact that it was scheduled to be delivered at 10:30. The detention in this case was whenever this package was taken out of the normal process as well. Because the evidence in this case was that it arrived at the facility at 6:30. The UPS person had it as late as 8, but the drug dog isn't even there till 10:15. So it's the whole detention, and results in it being delivered way after the deadline. But it's that whole detention that we're arguing. The Court of Appeals didn't get to that, so I don't know that that's really before you. But that's what we would argue, that the fact that the drug dog hit at 10:15, the detention was already too long at that point, is our argument.
Okay. Any more questions?
Thank you, Your Honor.
Counsel.
Mr. Chief Justice, and may it please the court, I'm Jacob Gunteski. I represent the state of Kansas, the plaintiff, the appellee in this case. Before going into my response to Mr. Hodgkinson, I'd like to point the court to volume 35, page 35 and 36 of the record on appeal. That is the motions transcript from the hearing on the defendant's motion to suppress. The question was posed to the officer who was investigating, Mr. Tone. The question was posed to him about that package watch that he had requested of UPS, and his response was, I contacted UPS Inspector Carr, briefly gave him some background to the investigation there, and I asked or requested that he place a parcel watch, and I'm summarizing here, on 157th Terrace, quote, specifically looking for any packages shipped from California to this address. So the parcel watch that was made was specific to parcels from California. I would start out by saying, number one, reasonable suspicion was not required for detectives to bring their canine to the UPS location and commence a sniff of those packages.
You're claiming there wasn't a seizure here?
Absolutely. Not until the officers took that package from UPS back to the department.
Okay.
And when officers requested that UPS put a parcel watch on it, no seizure had occurred. The testimony is a bit ambiguous as to exactly when officers were called by UPS, sometime during the 8 or 9 o'clock hour. But officers acted diligently in their investigation throughout the day on this case, and the testimony was very clear to that effect when Detective Stein was on the stand, and he talked about the time constraints he was working under. He recognized the package was delivered late, but getting back to that.
So it didn't leave the UPS until sometime after the drug dog hit, but was that sometime after the 10:30 promised delivery time?
That's a very good question. It was somewhere very close to the 10:30 delivery time. The testimony was ambiguous as to exactly whether or not it was before or after.
Does it make a difference?
I don't believe it does.
Why
not when we're talking about whether or not the seizure was reasonable. That's part of the calculus, but it's not as though UPS called officers and said, hey, we've got a parcel here. that matches the description you requested.
Can you back up here? The seizure was reasonable. Are you talking about the seizure once the officer arrived at the scene, or what took place prior to that time?
Both.
When it was kind of.
But
so there was a seizure
there was a seizure when the officer
prior
got
to
there.
to the drug sniff.
I don't believe there was prior to the drug sniff, because I don't believe there was any reasonable interference with Mr. Tone's possessory interest in that package
Do we
prior
have
to
any
officers'
evidence that
arrival.
it got pulled off a truck, or or that it would have by that time been on the truck? I mean, if they're promising delivery at 10:30, at 10:15, wouldn't that package have been on the truck? I mean, do we have anything in the record that tells us about the process at UPS and whether it got interfered with?
We don't, but presumably it would have been on its way, but we don't know that for certain. I even cited to a case in which UPS acknowledges that packages are often late after even on next day air, they can go late. So reasonable suspicion wasn't required for officers to bring the dog to UPS and sniff these packages that had been lined up in the room.
But
Once they did,
you're saying that law enforcement can go investigate or look at items that are in the mail without reasonable suspicion.
if UPS allows officers in to sniff those packages, absolutely. I would liken it to officers walking a canine around a car that's parked along the street, walking it through a school, past some lockers. There's lots of instances in which officers can walk a canine around an object or a place and see if it alerts. Even if that person hasn't been told, that doesn't implicate their possessory interest in that item. Mr. Tone's possessory interest in that package was not impeded when officers took that canine to UPS and sniffed out that package. And once that dog did alert on that package, probable cause existed for officers then to seize that package and work through the day to obtain a warrant and then proceed to open the package, deliver it to the house, and go into the house.
Argue with me about this, because it seems to me, I mean, looking at all these different tests about when a seizure occurs, I'm more drawn to the delivery time because it's a point that you can really articulate rather than look at a bunch of stuff that's more general. But so it's promised delivery at 10:30, and at 10:15 is when you show up with the dog. The package isn't going to make it by 10:30. That seems pretty obvious. So it seems to me that's a seizure. Now, just that's the way I'm looking at it. Talk me down off of that.
We don't know exactly when UPS diverted the package from the delivery stream. Sometime after 6:30 a.m., sometime before 10:15. The testimony was the package would have arrived at the UPS facility through their next day air process sometime around 6:30 a.m. that morning, and it was due to be delivered by 10:30 that morning. So that's the window that we're working in, is somewhere within that 4-hour window. The testimony from the UPS investigator, I believe, was that he contacted police sometime during the 8 o'clock hour. The detective, I believe, testified it was sometime during either the 8 or 9 o'clock hour that he was contacted. So to the effect that there was a seizure, if your premise is that there was a seizure the moment that package was diverted from the delivery stream, presumably it would have been sometime during that 8 or 9 o'clock hour.
Well, pulled from the delivery stream to such a degree that you weren't going to make your delivery time.
Right.
I think if you would have had the dog there at 8 and had the sniff, and then it could still get on the truck and be there by 10:30, you know, there's a whole different argument. I mean, I'd probably be with you there. But you're not getting this guy's package to him in the normal stream, and that seems like a government-induced seizure of that package, just by definition.
And I disagree with seizure, but taking that premise, my response is, if it was a seizure, it was a reasonable one, even without a warrant, because it was so brief. It was so brief because if it was diverted from the stream around that time, around the 8 o'clock hour, then it was only diverted for tops a couple of hours.
But now I'm at the next step, and I'm just trying, and you're trying to tell me I don't even go to the second step, and I'm telling you I think I got to. Now I understand your argument at the second step. But I'm trying to figure out whether we have anything to talk about on the second, whether we get to the second step.
Understood.
And I just can't get past the idea that this isn't a government-initiated detention, that package isn't going where it's supposed to go because of the government. It just seems like we ought to be talking about the reasonable suspicion for you to be able to do that.
And I'm happy to, that's why I raised it basically in the alternative, first arguing reasonable suspicion was not required for the sniff, but then responding that even if it is, reasonable suspicion was present here. So I'm happy to argue that it was present.
Why don't we move you over, though, to the length of time and this whole preservation argument, because that's interesting, too.
The length of time and the preservation argument, if you go back to how the case was argued at the district court and you look at the motions that were filed, the motion to suppress from volume 3, pages 28 through 30, I believe it was Justice Breyer highlighted earlier. In that, it was Justice Lukert that highlighted it was rather a bare bones motion. And Mr. Hodgkinson states that the argument at the district court level was that this was an intrusion upon Mr. Tone's Fourth Amendment rights. But if you actually look at the motion, it was even more general than that. His motion doesn't even mention the Fourth Amendment. His motion mentions, quote, prior to interfering, the government must have reasonable suspicion, and quote, the seizure was a violation under the Kansas and United States constitutions. And in that motion, he cites one case. He never mentions the Fourth Amendment. He never mentions the length of time.
But everybody knows we're talking about the Fourth Amendment when somebody says reasonable suspicion.
True.
That's actually more particular than saying the Fourth Amendment.
True.
Yeah.
True.
So I mean, no one's misled about what's at issue here.
Well, you could
We're
argue.
just saying it has to be more specific.
True. It absolutely has to be more specific than just stating it's about the reasonable suspicion aspect. Because the state in the motion, and you'll find in the transcript of the motion, the state even started talking about the length of time that day in examining Detective Stein on the stand and asked some questions about how the day progressed, how he got to the store, how the drug dog alerted on that package, what he did with that package. He had another detective take that package back to the station. He went to work on the affidavit and the warrant. He proceeded through that process as quickly as he could. Then he took the warrant to the district court to get a judge to review it. Around the 3 o'clock hour, it was signed. Once that warrant was signed, it was 2 warrants, one for the package and an anticipatory warrant for the house. Once he got those, he then relayed that information back to the station. Before he even drove back, he relayed to them, hey, I've got the warrants now. Open up the package, find what's in it. We have the authority to do that. And let's see if we need to get it delivered to the house, what's going to happen next. He didn't even wait to get back to the station to open it. He knew, per his testimony, that time was of the essence that day. He was working as diligently as he could. But
I don't think the defendant's taking any issue with anything that happened after the dog sniff.
Well, I think he is
they're
to the extent that
arguing
he's arguing since it wasn't delivered until after 5 o'clock, that length of time was unreasonable.
That counts as well, even though by that time there was probable cause.
My understanding is that was
his argument. Okay.
that was my understanding. Was part of his argument was that length of detention of the package all the way through until it was actually delivered after the 5 o'clock hour. And my response is that that issue was not preserved. Even the length of time before the 10:15 sniff was not addressed by defense counsel, particularly at the hearing in which the detective testified and UPS testified about the procedure that was utilized that morning. This is a fact-intensive inquiry, the issues about the time constraints, and you don't have before you all the facts that could have been developed at the district court level had that issue been squarely addressed at that stage. That's why it would be inappropriate to pass on the issue now to address it on the merits, because we don't have further inquiry of the detective or of UPS about the time constraints, about the drive time to and from different places, about when the dog arrived, how long the alert took. We don't have issues getting later into the day about how long it took him to draft the affidavit, draft the warrant, take it out to the district court on a weekday, wait for a judge, presumably, who has a docket, and see if the judge can review it, sign it, and so on. It's not an instantaneous process for a detective to obtain that warrant and so on. So that length of time of the seizure was reasonable from the moment the officers got the call. If we're saying the seizure occurred at the moment it was diverted from the stream, from the moment the officers got that call, he reached out to a fellow officer who had a dog and said, we need to meet at the Lenaxa UPS station. They met there. They worked diligently throughout the day. I understand.
Was that argument made at the district court, just what you said?
The state did make that argument.
Okay.
It did. It's not as fully developed as a record. It is not as fully developed of a record as it would have been had that issue squarely been raised by the defendant. But there are points raised by the state when they were examining their own witnesses on the motion to suppress. And the judge at the time even interjected at one point when the state was arguing the issue about time. And the judge interjected along the lines of, I don't believe the defendant's even arguing about the length of the seizure here. I don't believe that's the crux of his argument. I think the crux of his argument is, did officers have reasonable suspicion to commence the sniff? And so a defense counsel didn't stand up, didn't say, well, actually, the time is my issue here. Defense counsel never circled back to the time issue when the judge made that statement during the motions hearing and so on. So we have both the motions hearing and then we have later the ruling on defense counsel's, the defendant's motion for reconsideration. And it was during one of those two hearings in which the judge made that statement. This is not the crux of the issue here. It's not about the time. So I understand the court's hesitancy in finding that there was no problem in the package not being walked around by the dog until 10:15 when it was already going to be late. But my response is that even if that is a seizure and it constitutes one, that it was a reasonable one. Under the Fourth Amendment, we're talking about reasonableness. And I know that we didn't have a warrant at the time the 10:15 sniff occurred. But that short delay in when that package would have been delivered, had the dog walked around and had no alert, then presumably that package would have gone right back into the stream and would have been delivered, albeit a bit late. But I don't believe as though that impeding the delivery time by that short of an amount of time so substantially impaired Mr. Tone's possessory interest in that package to rise to the level of suppressing that evidence.
Was the 10:30 time the outside limit?
10:30 was the outside limit for the next day.
So we don't know whether it might have been delivered at 8:30.
We don't.
And so the delay may have been longer than you're arguing if it hadn't been taken out of the normal stream. And then my next question is, when Carr took it out or affected the taking out of the normal stream, was he acting as a government agent?
He essentially was. It was not an order by the state for him to do so. It was a request. But under case law, he was an agent of the state.
And so what we have is a governmental agent taking this out of the stream at least 8-ish, to be generous on the time frame. And so really, why wasn't that a seizure when a government agent took control of that package and diverted it from the normal process?
It wasn't a seizure because Mr. Tone didn't have possessory rights in that package at the time until it was delivered by UPS, and UPS had until 10:30. And the case law is clear that packages that are released to a third-party carrier for transportation and delivery, the owner of those packages, or the recipient, the to-be recipient, has substantially diminished possessory interest in those packages when he releases them to a third-party carrier, such as the case here. This package wasn't even addressed by name to Mr. Tone. It was addressed to a fictitious individual at the same address. Ms. Woodland, I believe, was the name on the package. So Mr. Tone had diminished possessory interests in that package. Those were not substantially impaired, even if the seizure was effected at around the 8 o'clock hour by government agents, as you put it, Mr. Carr of UPS. But even if it was, reasonable suspicion occurred. The issues that were raised by opposing counsel, this court's task is not to pigeonhole each of those facts, as you mentioned, Justice Breyer, into whether or not there's an innocent explanation. Otherwise, every DUI investigation without a breath test would end in an acquittal. When we have bloodshot, watery eyes that can be explained by allergies, when we have stumbling that can be explained by Parkinson's or a bad knee, and when we have bad driving that can be explained by the wind. But when we take the totality of those circumstances, what officers had here were 2 visits by the supplier to the CI to that home within days, each lasting around 10 minutes. That supplier then made a buy that he delivered to officers that was high-grade marijuana. Those visits were not spread out lengthy in time. This entire investigation lasted from the 1st of the month until the 20th. And so we're talking about a period of time in which 2 buys were made, officers obtained some of that marijuana and confirmed as much. They determined the individual living in that home had the gang affiliation background, criminal history from California. They had information that the high-grade marijuana was being delivered by UPS from California. Those were the specifics that they put on the parcel watch. And that parcel hit on the 20th of the month, close in time to when the request was made to UPS. When we take the totality of that, reasonable suspicion absolutely existed, both to divert it from the stream, but absolutely to walk the dog around it around the 10:15 hour. I realize I'm out of time. I'd be happy to go on if the court has any questions.
Any more questions? Thank you, counsel.
Thank you.
Mr. Hodgkinson, could you enlighten me? Am I misunderstanding your claim about the time delay? You're talking about the entire time from when it left the delivery stream until it arrives at the house.
We are citing that as evidence of the type of delay resulting from the illegal detention.
Okay.
So, as
But
I
even though
admitted
after-
earlier, there was I think there is
Yeah.
probable cause at the time of the dog sniff.
Right.
But our argument still is that, yes, that other time is still being considered as far as the fruit of the detention, what we are alleging is the illegal detention, the detention that took place before the dog
I'm just
sniff.
it's confusing to me because, the detention, the temporary detention ended when that dog sniffed, right? in
No,
essence.
no. Okay, yeah.
Okay, I'm just having a struggle here.
Sure.
Obviously, maybe you can help me out.
If that dog sniff took place during an illegal detention, no, right? It's still illegal.
Yeah, the sniff itself was a product of illegal.
That's
detention.
right.
That's your argument.
Yeah, and let me clarify, in your petition, you state, as a result of the package being delayed 6.5 hours past its scheduled delivery, in the absence of reasonable suspicion, the delay in this case cannot be justified. That's how you frame it. And that's qualified by the absence of reasonable suspicion. So if we find there's reasonable suspicion, what does that do to the delay?
Yeah. So even if you disagree with me, and if you are of an opinion that the dog sniff does change the calculus at that point, you still have this delay from whenever that package gets to the UPS, whenever they took it out of the regular delivery stream, to this investigation at 10:15. And that question of that delay, warrantless without probable cause, is still before the court. And our argument is that delay itself is excessive when you look at Place and other cases like that.
That's more how I understood your argument, is that that's when the timing was really important.
And so help me in trying to decide that this earlier period before the dog sniff is excessive. What are the criteria upon which we decide that it's excessive?
Sure. I think you're looking at how is it interfering with the owner's possessory interest. And that's where I would tie this in, this sort of example of, I think you're hitting it on the head, just Kyle, this idea, you can imagine a situation where
I'm
the
waiting
dog's
for an
right
answer
there.
if I'm hitting it on the head, because I still don't know what the test is.
Did it change the situation with regard to that person's possessory interest in some way? Did it make them not have possession of it when they would have otherwise had possession of it?
You mean delivery?
Yeah.
And so how do those facts get developed if you don't raise it at the trial court level?
We think that it is sufficiently raised. It could have been raised more, maybe. I can see a world where you do ask more questions. I understand I have to make the claim based on the record that I have, but as sort of has been noted, I think it's fair to argue from the record that we have that had they not done what the government asked in this case, there's no reason to believe UPS wouldn't have delivered this by 10:30. If they'd left this in the regular delivery stream, there's no reason to believe it wouldn't have been delivered on time. But what we know is because of the actions the government took, it wasn't delivered it certainly wasn't delivered by 10:30 and really wasn't delivered till about 5 o'clock. And so we can see, this is, when we talk about, and we look at place and these things, this idea of interference with the possessory interest. Your Honor, if there was a situation where they had the drug dogs there, like you suggested, I think it's hard to say that, look, it was in the ordinary course. Nothing changed about what we did with this from what we ordinarily do with this.
The linchpin is still reasonable suspicion, though. If they had reasonable suspicion and you didn't get your package at 10:30, the length of the delay is not going to be an issue.
It still is. I mean, it still has to be, because we're really working still under the Terry doctrine, right? For this reasonable, if we're thinking about, we get to detain this package, it's still like a Terry stop of the package. And so the length of that has to be short.
And I'm thinking that if that's the case, it requires more factual, I'm getting back to preservation. It requires more factual development at the trial court level, and that factual development didn't occur because the defendant didn't raise his hand on that issue. And that's a classic preservation problem.
In fact, said that is not the crux of this issue. That's what the court said, and there was no.
I mean,
well, maybe we can get you to invited error like we did in the last case, and then decide whether that's structural or not.
Yeah, I mean, again, I would liken this. I understand I have to work on the record I have, just like I do when I'm doing a sufficiency issue. If I'm saying they didn't put on evidence of some fact, I still have to deal with the record I have, and to the extent that there are factual disputes, I'm dealing with them in a light most favorable to the state. And I think that's true here. I don't think there's any great dispute about the facts here. I don't think there's any great dispute about the fact that this package was taken out of the ordinary delivery scheme, and because of that, it was not delivered by 10:30. In fact, wasn't delivered until quite a bit later. So my argument is all based on this. If you think that record doesn't support my claim that something was out of the ordinary with this, then you would be right. I mean,
but
we hadn't developed that record.
It's not, when we're talking about preservation, that's not the question, is it? Is whether the record would support your argument. It's whether or not we can even get to the merits.
That's right.
And so, back to preservation, I guess my question, circling all the way back to, I think, what Justice Lukert asked with respect to the statute, is how was the motion sufficient to preserve this issue in this case? And I think your earlier answer is, all we have to do is say it was a warrantless. There was no warrant. Is that right?
I think the law is that a warrantless search is per se unreasonable.
And so...
A warrantless seizure is per se unreasonable.
Well...
I don't have to do anything more to establish the unreasonableness
It's
of a
presumptively unreasonable. Is it? Is that the same thing as...
It's presumptively unreasonable.
The statute says you have to assert facts, state facts, showing wherein the seizure was unlawful. And just saying there was no warrant, it gets you pretty far down the field, but it doesn't get you over the goal line, does it? Go ahead.
I think it establishes that it's illegal until the state meets its burden of proving that it was legal. I don't think I have to do anything else. If I stand up and say it was a warrantless seizure and the state says we don't have anything to say, Your Honor, yeah, I think we're done. It's not partially down the field. We're done.
You don't bear the burden of proof, that's true. But the simple fact that there's no warrant, I guess if that's the only fact. Yeah.
The simple fact means that it's per se unreasonable, subject to the state's burden of proof to show it's legal for some reason.
The second sentence of that statute says, the judge shall receive evidence on any issue of fact necessary to determine the motion. That makes it sound like the statute's really aimed at narrowing, because these are fact intensive, and the purpose is to get some fact findings. Doesn't that seem to indicate that there's some responsibility on the defendant to raise the issue?
I guess I feel like that would be turning the burden of proof on its head. And in fact, as I was reading the state's supplemental brief that they filed in this court, my colleague notes that in discussing this, talking about how my client never rebutted Judge Bornhold when he stated from the bench that he didn't believe that this was the crux of the issue. I mean, I didn't disprove it. That's what the state's saying. I have a burden of proof, and that's not what the statute or the law says in a suppression issue.
No, but you're saying that the trial court and the state have to litigate even issues for which there is no dispute. Because an ADO in Topeka is going to pick up on everything that there wasn't a dispute on, but because there's not a record, you're going to create an issue about that. And this is designed so that the statute's designed so that everybody can focus their attention on whatever the problems are, and then develop a record and decide it, and then be able to challenge it later. That's the problem. And I can't figure out when that music stops for the defendant if we adopt your viewpoint. I mean, can you literally show up here for oral argument and come up with a whole new Fourth Amendment reason, and the state has to think on its feet and try to demonstrate why the Fourth Amendment wasn't violated because of some argument that you came up with last night?
Obviously not, Your Honor. I mean, obviously I have to brief an issue to talk about it to an appellate court. And I did brief this issue. The problem was the Court of Appeals said that it wasn't raised below, and therefore we couldn't talk about it on appeal. Your Honor, as I was sort of thinking, as I was sitting thinking, I was sort of thinking about other cases where we think about the state having a burden of proof. And again, I think about cases this court has held where, for example, like, we get into issues of gruesome photographs or things like that. And even where the defendant stipulates effectively to the person, the decedent's death or things like that, this court says the state still had the burden of proof of those facts, and therefore, for example, those kind of things are relevant. The idea that unless the defendant stipulated to a particular fact or element, the state has the burden of proof. And so what can we raise? What will the record bear out? That's what we should be able to raise to the extent that we've asserted that there was an illegal search, which we did in this case.
I think the difference between the example I think you gave in your opening argument about the state has to prove all its elements is that here the state has to guess as to what those elements are because the defendant won't tell them.
The state doesn't have to guess at all, Your Honor. In this case, we said this was a warrantless seizure. The state chose, and they could choose more than one, but they chose to say, we think reasonable suspicion supported this seizure. And a component of that then is, that might be right, but only to the extent that the seizure then is for a reasonable duration linked to that.
And if the state guessed wrong, that was the issue that you were holding on to, then you come up to the appellate court and say, I wasn't going to argue reasonable suspicion, I was going to argue something else, and there was no response. And so now we're looking at that afresh. That's the problem I have with your proposal.
If the law is, which I think it is, that a warrantless search, for example, is per se unreasonable, that's what we say. That's going to put the state on a burden. The state then has to come in and prove one or more reasons why, even though it was a warrantless search, it's legal. And then we're going to be able to evaluate on appeal fully one or more of those claims.
You're talking. Everyone's talking past each other. You're saying that once you say there's no warrant, that establishes the illegality that the state has to refute. And my colleagues are saying, no, the defendant has to say why it was illegal. And you're saying that once you establish the warrantless, that's the illegality is on the table. So we're just talking past each other, but I mean that's the argument on both sides.
I think one of the difficulties here is that reasonableness, although it may be the touchstone, it's referred to that way sometimes, we have specific exceptions to the warrant requirement. So when the state picks a horse to ride, that has requirements that attach to it. And if the horse they're riding is that this was a Terry stop of a package, which is the horse they're riding, then that has elements to it. And you're saying this is one of the elements. It can't be too long.
And the state recognized it. The state recognized it on page 8 of their own brief, in the opening brief in this case, talking about there was no indication the package was delayed for a significant amount of time because of the canine sniff. I mean, they recognized it as a component. If, Your Honor, if you adopted the opposite view of this, then the defendant, I mean, my colleague aptly noted that, how many exceptions to the warrant requirement are there? Does my motion to suppress have to say there was no warrant and this doctrine doesn't apply, and this doctrine doesn't apply, and this doctrine doesn't apply, and this doctrine doesn't apply? That doesn't sound like the burden's on the state. That sounds like the burden's on the defendant to disprove every possible response for the state. And I don't think that's what the law is or it should be.
So maybe did your motion actually get too specific when it talked only about reasonable suspicion and led everybody to believe that was the sole question? Or are you saying time is also wound up in reasonable suspicion so that it was obvious that it was there?
I'm saying it's wound up in it. The cases, even the Daly case that was cited and talked about below, wraps it up in that. So I think that's anytime you're talking about Terry, any Terry stop, I should know as a state or the defendant or anybody that it's not just about was there reasonable suspicion, but also was the duration of that stop appropriate. That's just a component of a Terry stop.
And then did your colleague at the trial court level have an obligation to correct the court and redirect the court to say, no, Judge, you need to be considering the length of the time?
Well, it's not whether the judge considered it, it's whether the state proved it. And to the extent that the state was worried about or concerned about whether they proved it and made a record, that's what they would have to be worried about more. Or, I mean, I can see a world where also maybe the judge goes, look, I want to be real clear, defendant. You talk about invited error. I want to be really clear, defendant. You are affirmatively saying you have no claim regarding the duration of this stop. Are you affirmatively saying that? Yes, Your Honor. I'm going to be in a difficult position then for the reasons you talked about before, Justice Black. That's not this case.
Any further questions?
Thank you, Your
Counsel.
Honor.
Thank you both for your arguments this morning. The court will take this matter under advisement. This